So we're just waiting for all of the participants to join in, but to those who have connected and to those that are in the process of connecting, let me, Brian Spears, welcome you to the third in a truly excellent series of discussions, updates and analysis of cases within the Privy Council. I am the president of the Commonwealth Lawyers Association, and it's a really great privilege to both have listened in to the previous two and to anticipate the third in this three-part series of discussions. This time, our expert team has been augmented by Desiree Artesi, and it's lovely to see you here, Desiree. We saw you last at the Commonwealth Law Conference in Nassau, the Bahamas in September, and we look forward to this group and everyone listening in considering attending our next Commonwealth Law Conference in Goa, India, starting on the 6th of March 2023. Really not that long to wait, I'm pleased to say, and Goa is turning out to be a really exciting destination. And we're looking forward to bringing more details of that conference. As I said in my opening remarks on the first two events, the Privy Council case law and jurisprudence is, of course, of wide relevance throughout the Commonwealth, and not just to the countries for which the Privy Council is the final court of appeal. And we very much appreciate the work that has gone into arranging these. It's an example of what the CLA can do. We look forward to receiving suggestions for more similar series on other topics. And I'm looking forward to this session very much indeed, and thought that I should just bring a greeting on behalf of the Commonwealth Lawyers Association. And Lord Carnwath, you are back in the chair to take us through session 3, and over to you, and thank you for chairing, and thank you, the panel, for your preparation and sharing your knowledge with us.
Well, thank you, Brian. Nice to see you again. Nice to be back. Happy New Year to everyone. Some of you no doubt have been on our two previous sessions and will be familiar with the format. As Brian has said, we've Richard, Clayton and Rowan, Pennington-Benton are familiar faces, but Desiree has joined us and she may be familiar to a lot of you, but it's very nice to see her here. The idea for this session is to move on sort of more procedural and practical matters, and in particular issues like concurrent findings of fact and how you deal with that. I think Desiree is going to be looking at cases where there's an appeal as of right, and sometimes that may not amount to very much in practice, but we'll see how that develops. And then at the end of the session, I'm going to be offering a few suggestions from my own experience. And I may say it's been, having sort of retired from the Supreme Court in March 2020, and having done a fair number of Privy Council cases as a judge, it's been quite interesting over the last year or so, finding myself asked to advise people presenting cases to the Privy Council and what are the traps and what are the things to avoid and the things to do. So I'll be perhaps giving a few thoughts on that. Now, you can ask questions. There's a question and answer tab at the bottom of your screen, I think. So if you have questions, you're very welcome to put them there, and we'll try and find time to deal with them at the end of the session. The session is due to last about an hour, although we might extend it if there's particular questions to deal with. But we'll start off then with Richard and Rowan, I think in that order, and we'll see how they proceed. So, Richard, over to you.
Well, I think actually we flipped that order just to cause a degree of confusion. And I'm going to be starting off talking about concurrent findings of fact. And then Richard Clayton QC will take over and deal with some of the examples, ways in which we can sort of get around the rule against concurrent findings of fact.
Okay, well, I'm sorry I got you wrong, but
Right.
shows that I'm not a very good chairman. Anyway, far away.
Well, Rich and I are frequently mistaken for each other. So the basic practice or rule, as it's being called in the Privy Council, is that it will not entertain appeals against concurrent findings of fact of the two courts below. It's a very long-standing, self-imposed rule of practice. It's a very common point to be taken, we find, in appeals to the Privy Council, but is also a common factor that appellants or respondents don't necessarily get their heads around the problem until late on in the day. So we thought it would be a useful subject to cover here. I've started with a case called Allen, A-L-L-E-N, against Quebec Warehouse Company. It's a case from 1886 from Canada, 12 appeal cases 101. I think we're going to put together a note after this that's got all of the citations and so on in. And the judgment in that case, the board said it has always been the view taken by this committee in advising Her Majesty when the question for determination has been whether concurrent judgment of the judges who have been unanimous below, it's an important point we'll come back to in a minute, should be supported or reversed, that unless it be shown with absolute clearness that some blunder or error is apparent in the way in which the learned judges below have dealt with the facts, that this committee would not advise Her Majesty that the appeal should be, that the judgment should be reversed. So perhaps in its original form, it's not a particularly controversial statement for any appellate court to make, but particularly a second appellate court, which in a number of different respects is twice removed, if I can put it like that, from the local jurisdiction. However, if one traces the development of the practice through into at least into the 20th century, we end up with a decision called Devi and Roy, D-E-V-I against Roy, R-O-Y, 1946 appeal cases 508, an appeal from India. That's often the starting position of any modern statement of the application of this rule against delving into concurrent findings of fact. And it states the position really somewhat more as a hard-edged, high threshold rule. And I can take it really from the head note to that case. Number one, the practice applies in all cases from various jurisdictions which appeal to the board. Fine. Point number two, it applies to the concurrent findings of facts of the two courts, i.e. the two courts below, and not to concurrent findings of the judges who compose such courts. Therefore, a dissent by a member of the appellate court does not obviate application of the practice. Point number three, the difference in the reasons which bring the judges below to the same finding of fact also will not obviate practice. In order, this is number four, to obviate the practice, there must be some miscarriage of justice or violation of some principle of law or procedure. Miscarriage of justice, it's said in this context, means such a departure from the rules which permeate all judicial procedure as to make that which happened not in the proper sense of the word judicial procedure at all. So not only has it developed into a practice where the board apparently on a second appeal won't interfere with concurrent findings, unanimous findings of fact, we're now also not interfering, it's said, with concurrent findings of fact, whether or not they were unanimous, even if the reasoning was different, and even then only if really something went so badly wrong as you couldn't properly describe the process as judicial at all. Devi and Roy, unsurprisingly, given the terms in which it the decision is made, is the first port of call for any respondent who's facing a potential petition for an appeal on concurrent findings of fact. And it has recently been effectively restated by the Privy Council in a case called Das and Marchant, DASS against Marchant, MARCHAND, 2021 UK PC 2. This is an appeal from Trinidad and Tobago seeking to challenge findings effectively that a woman had been tricked into a conveyance, and the board declined to review the findings of the High Court and the Court of Appeal on that point, and Lord Burrows expressed a position as follows. The first point he said at paragraph 15, we do not think it appropriate to go behind concurrent findings of fact of the lower court, although there can be rare exceptions, he said, to this practice, in particular where there has been an error of law. Well, pausing their query, if there's an error of law, then you don't need to worry about an error of fact because you've got an error of law. This case, in any event, he says, falls far short of coming within such an exception. The practice of the board, he says, imposes, I quote, a super added constraint on this appellate court, goes beyond the standard constraints of an appeal court and adds an additional hurdle for an appellant to overcome. He gives several reasons in support of that practice, including that the trial judge, as is often said, had the opportunity to see and hear the witnesses firsthand. And the Privy Council also, his lordship says, wishes to respect factual circumstances peculiar to the country where they exist and from which the case comes. So with all of that introduction, you may be sitting there thinking to yourself, well, goodness, it's basically impossible to get past this hurdle where there are concurrent findings of fact. However, the case law does demonstrate, once one has a careful analysis of it, that there are a number of different ways in which appellants can actually persuade the board to intervene in concurrent fact cases. Now, we've tried to segregate these into categories, which is not particularly easy to do, as there's a good degree of overlap, but and just bear that in mind as we give these examples. But the first category we've referred to as where the structure of the judgment or the judgments below indicates some error of process in the assessment of the evidence. And the example I give for that is a case called Cleary. I've given this case before, I think, in our earlier seminars. CLEARE. It's from the Bahamas, 2017 UK PC 38. Mr. Cleary, to put it bluntly, claimed that he was beaten up by the police in custody. His claim was rejected by both courts below. And the appeal to the Privy Council generated a letter from Lord Mance at the time to us, representing the appellant, saying in very polite terms, well, this is all very interesting and your appeal is coming up, but really there's concurrent findings of fact. What do you say about that? So it made us really spend quite a lot of time looking into the law on concurrent findings of fact. And in the end, we did succeed in that appeal to persuade the law, the board, that what the judge had done is he'd assessed the lay evidence of the claimant and the witnesses, decided and expressed himself in the judgment as not believing that evidence, and then he'd gone on later in the judgment to consider the medical evidence, including evidence of an hypoxic injury. And one of the allegations was to put a bag over his head. So what the board basically said is he was wrong to compartmentalize his assessment of the evidence in that way. He was, quote, wrong to reject the appellant's evidence as untrue, indeed as fabricated, without considering it in the light of the medical evidence which was said to corroborate it. Reference was made to the well-known case of the Ocean Frost and Robert Goff LJ's judgment. It's first importance to test the veracity of a witness by reference to the facts ascertained independently of his testimony. I'm going to hand over to Richard very shortly, but query whether actually in reality the judge had really conducted two separate assessments in that way, as opposed to simply expressed himself in that disjointed way in the judgment. The point is, if you can find some error in the structural judgment, you may just be able to use that as a platform to suggest that there'd been some error of process, and then you can go behind concurrent findings of fact. Right, Richard, I'm going to hand over to you for category 2.
Rowan, I don't know whether the references, someone has asked in the Q&A whether we can have the references. Is
Yes.
it possible to put those in the chat or something?
I can do that, certainly.
While Richard is speaking.
I'll do that while Richard speaks. Thank you very much.
Okay, over to Richard. Richard, you're muted. Richard, oh.
Is that,
You're
can you hear me
muted,
now?
you're muted. Okay, you're okay now, righto.
All right, sorry. Okay, sorry about that. As Rowan indicated, what we've tried to do is to indicate in broad terms the sort of cases where concurrent findings of fact might nonetheless result in a viable appeal. One of the cases that I talked about last time in the context of commercial cases was the Central Bank of Ecuador case. And that was a rather complicated case, as you may remember. The reference is 2016, one Butterworth's commercial law case is 26. And in essence, that involved a complaint that the defendants had dishonestly procured or assisted the director to breach his fiduciary duties, causing loss to the claimant company. The courts below both rejected those fraudulent allegations, and Lord Mance gave an extremely detailed judgment overturning the domestic courts on the issue of fraud. Now, what makes the case of interest really is that, and I think this is a continuing thread of the successful attempts to circumvent the concurrent findings principle, is that the trial judge had answered the issues in the case in the most general terms without analyzing the detail of the facts. And that, I think, is the hallmark really, or at least the central thread of the successful concurrent factual cases which succeed, is when the judges have taken shortcuts in the context of a complex case. So, as I said, if there's been an oversimplification in a complicated case, that is probably a starting point for dealing with a successful application to circumvent the concurrent findings. A slight slant on that is the third category, where that central complaint is assisted by other concerns, for example, about judicial demeanor and other sorts of procedural problems. And the example we've chosen to demonstrate that is a case called Byers and Chen, 2021 UKPC 4, where the board again intervened on the question of whether a director had wrongly procured the company to make a payment to a creditor, which amounted to an unfair preference. There were two concerns which I think ultimately colored the approach of the court, of the Privy Council or the board, but didn't prevail as independent arguments. One of them was that the trial judge's intemperate and immoderate interventions, both before the trial and even beginning at the pre-trial conferences, indicated apparent bias. And as you will all know, despite the enthusiasm in some countries for bringing apparent bias claims, that failed. And then there was a 2.5-year delay, which again is a regrettable feature that can happen, of the Court of Appeal dealing with the trial judge's approach. And that too troubled the Privy Council, but not to the extent that it reversed the case on that basis independently. In the end, the Privy Council focused on a particular point which the trial judge had found and which the Court of Appeal had accepted. And that was a factual finding that the relevant director had escaped liability because she had resigned in 2009. And the examples they gave are just helpful as an indication of a case has got to go quite badly wrong before you get a factual case like this off the ground. So the complaint, the finding was they had resigned in 2009. The board pointed out it was never the director or indeed the liquidator's case before the trial judge that they had resigned at that point. The conclusion was based on a false error by the trial judge. The judge had focused erroneously on the director's lack of involvement in the day-to-day management, which was an entirely different question and wholly irrelevant to whether she remained the director. There was in fact no evidence that she had resigned in 2000 and some evidence that she had not. And both the trial judge and the Court of Appeal had ignored the fact that the witness had undertook duties consistent with remaining a director. And they concluded this was an error of fundamental importance to the outcome of the appeal. It's one of those rare cases where it was appropriate for the board to intervene. Then another sort of example of that is where you have findings of fact made which are sort of so unusual or out of the ordinary to trigger concerns. Now, an example we've chosen, this is an example, not strictly speaking a concurrent findings of fact case, is a well-known Privy Council case about fairness, the Mahan and Air New Zealand case. That's 1984, appeal cases 808. You may remember that that's a complex case involving a number of issues arising from a public inquiry into an air crash. And to cut to the chase, what happened in that case, which was rather extraordinary, is that the challenge was decided the case was decided by the trial judge and accepted by the Court of Appeal on the footing that there had been a predetermined plan of deception on the part of officials of the airline, that he had, so that the case involved an orchestrated litany of lies. And that was just putting the case much, much too high. And that, I think, is another clue as to the correct approach to seeing whether there has in fact been there has been a proper basis to get around the concurrent findings of fact doctrine. In other words, where the finding of fact made is just bizarre and unjustified in relation to the evidence which the judge came before you. If it went too far, that may be enough. The next category of cases is findings of fact which are based on documents. And here I really want to make two slightly different points. The one is that obviously cases based on documents are different in terms of the importance of the trial judge's assessment of the evidence and his view of witnesses and so on. So in one level, a document case is more straightforward, where you're just simply arguing about what the proper construction of a document is. But that is not to say that the concurrent fact doctrine is displaced by a documents case. And in a case called, you'll forgive my French, the General Carrier of Mines and SG Hemisphere Associates, a Jersey case, 2013, one of All England's 409, the Privy Council held that the concurrent doctrine applied even though there was no oral evidence, but they got around that because the case concerned principally a question of mixed fact and law, whether the claimants, the appellants, constituted an organ of the domestic Republic of Congo for the purposes of public international law. And there the board decided, as slightly unsurprising, that that was a legal test, and the correct application of a legal test was one for the board to determine. So where does that take us in terms of what are the limits and what is the proper approach to concurrent findings of fact? Well, just a number of broad points worth making. It's undoubtedly a difficult and interesting area. It's wise, in our view, to get advice on how to structure the argument early on in order to overcome the difficulty, or if you're a respondent, to take advantage of the point. Sometimes this is left to the last moment when the appellants, sometimes under pressure from the board, reformulate some of their legal challenges to the findings of fact, which will be given short shrift by the board on the basis of the concurrent findings of fact doctrine. So it's worth to be forearmed and forewarned. In our view, the submission that the concurrent findings principle has most force are in cases involving complex legal arguments, where essentially the complaint is that the domestic court has taken factual shortcuts. Rowan and I will try to put together a paper which will develop this in a bit more length, and that's partly because we do find that's an interesting area to express views upon. Thank you.
Thank you very much, Richard. I mean, my own experience, some of the cases you mentioned were ones in which I was involved, particularly the Bank of Ecuador case, where really they were so complex. There's a good example, I think, of your shortcut point, that really the courts below analysed the rather complicated transactions in a way which really did justice to the facts. And so I don't remember if we said anything about concurrent findings of fact in that judgment. And I don't think we saw that as a problem in that sort of case. But it certainly is a very important principle in cases where one's dealing with straight questions of fact, particularly based on witness recollection and so on. So, well, thank you both very much. I think you've now put the case references into the chat for people who want them. And so now we turn to Desiree, who's going to move on to a slightly different subject. So over to you, Desiree.
Thank you very much. Well, hello and a warm welcome to friends old and new. Because of the limited time and the fascinating nature of my topic, the talk will focus in particular on the tests applied on an application for conditional leave in as of right cases. And of course, that will cross over into permission to appeal or special leave in as of right cases where the court below has wrongly refused permission to appeal. What role the Court of Appeal have in local jurisdictions to refuse leave to appeal, even where the appeal is of right? Abuse of process, correct characterization of the appeal, the value of the appeal in civil cases, and whether the appeal raises a genuinely disputed issue in the relevant category. These are all some of the issues which are thrown up on such an application. It's an interesting and developing area in the context of the role of the Court of Appeal in granting or refusing in leave in as of right cases. And so we'll look briefly at some cases and compare the traditional approach in the case of Eric Frater and the Queen, which is arguably the genesis of the genuinely disputed issue test. And that's a 1981 case, Weekly Law Reports 1468. And again, I wouldn't go into full citations, those will be provided afterwards. So we compare the traditional approach starting point at Eric Frater and the Queen, as opposed to potentially broader powers expressed in Maya and Baines, which is a 2019 case. And there is some evidence that Court of Appeals are seeking to exercise their powers rather more broadly to shut down what they regard as unmeritorious appeals. So how to make sure your appeal is protected. Now, the appeals that reach the Privy Council broadly, as we all know, fall into three categories. So you've got the appeals which are permitted as of right on the constitutional law, and those fall broadly into four categories. And then you've got the special leave, and special leave, of course, is now commonly called permission to appeal. This is where the Privy Council grants leave itself. And then, of course, you've got the category where permission is granted by the local court pursuant to the Constitution or law that allows them to do so. But what I want to do, because there's some crossover, is to focus in particular on the tests deployed by the Court of Appeals below when considering whether to grant conditional leave to appeal. So even if the litigant is entitled to an appeal as of right, the right remains, it's still required to be validated before and by the grant of formal leave by the local court from which appeal lies. Before that, the Privy Council will accept an appeal as of right. And so this is where the various tests comes in. And when considering whether to grant an application, the Court of Appeal's task may be broken down into a number of elements. First, the Court of Appeal must determine whether that appeal falls within one or the other of the prescribed categories. Now, this is important because the 4 categories, which we'll come back to when we look at the development in the law, you might recall, is first a final judgment or decision given in a dispute in relation to property or a right of a specified value. Then you'll have issues of interpretation of the Constitution, issues involving fundamental rights or freedoms, dissolution or nullity of marriage. It's the first 3 categories we will really focus on in our discussion. So bearing in mind the Court of Appeal's first task, I suggest, is to decide whether the appeal on the face of it falls on the pleaded terms of the appeal into one of these categories. Then the next task for the Court of Appeal is to determine whether a genuinely disputable issue arises in the prescribed category of cases. And this proposition of law comes, of course, from the case of Alan Forte and Attorney General, which is a 1997 case. A reference will be provided. And this involves asking the question whether the terms of the appeal disclose a real or genuine dispute or has merely been contrived for the purpose of obtaining leave to appeal to Her Majesty in Council as of right. And that proposition comes from Eric Frater case, which I'll provide a reference for in due course. You can have a look at those cases. Now, this question as to the genuinely disputable issue, I suggest, is no more than part of the overarching analysis of whether the appeal is an abusive process. It's a way of weeding out abusive appeals. So arguably, so long as the Supreme Court gave a substantive judgment on the issues arising in the exercise of its jurisdiction, pursuant to whatever the relevant article of the Constitution is, and then the Court of Appeal gave a judgment on appeal therefrom, I suggest that that could in effect be the end of the matter, subject to the question of abuse. So then the only remaining question for the Court of Appeal below would then be whether it was abusive for the aggrieved party to exercise his or her constitutional right to appeal onward to the board. So let's start at the case of Eric Frater, which seems to be the genesis of this genuinely disputable test. It was first applied to fundamental rights appeals involving questions of interpretation as opposed to application of the Constitution. That was Eric Frater. Then it was expanded to all fundamental rights appeals. This is the case of Alan Forte. And then expanded further to apply to civil appeals generally. This is where Meyer and Baines comes in. You can also look at our AVR to our 2018 case. But there's a very important point to be made here. And that is in relation to certainly Meyer and Baines and AVR 2018 and 2019 cases of the Privy Council on this point of genuinely disputable issue test. These 2 decisions conflict with the position adopted by the Caribbean Court of Justice in LOP Investments and Demerara Bank, which is a 2009 case. In those cases, what the Caribbean Court of Justice said was that the genuinely disputable test had no role to play in general civil appeals where the question is simply twofold. One, whether the appeal was civil in nature, and then secondly, whether it met the prescribed value threshold. And interestingly, that view was shared by the Court of Appeal of the Bahamas in the case of Blue Illusions Limited and the Minister of Agriculture and Marine Resources, which is a 2017 case. So are both of those decisions now to be regarded as wrong? In Meyer, the board considered that the same reasoning applied to appeals from the Court of Appeal of the Eastern Caribbean Supreme Court, and that the Court of Appeal had, and I quote, a right to police applications of this kind and to consider whether any proposed appeals raises a genuinely disputable issue. With due respect to the board's decision in Maya, there was not in the end very much analysis of the nature and scope of the Court of Appeal's power to police applications and what it really means to determine the existence of a genuinely disputable issue. Does the Court of Appeal's power extend to refusing leave where it considers the merits of the appeal to be poor, very poor, unarguable, or is it restricted to questions of abuse? So although the board was clear that the Court of Appeal's rule did not involve the exercise of any discretion, it is not clear that this excludes the possibility of some sort of merits review if this is thought a necessary part of the policing process. Now, in Blue Illusion's judgment given by the then president of the Bahamas Court of Appeal, Dame Anita Allen, she says this, and I quote, "I wholeheartedly agree with the Caribbean Court of Justice in its disposition in LOP of the question of whether the Court of Appeal may refuse leave in all as of right cases where the applicant is unable to demonstrate a genuinely disputable question of law or fact. Indeed, I agree that Lord Nichols did not in Alien 40 extend the principle to all cases of appeals as of right, as the Court of Appeal found in Singuinet. Now, Singuinet was a case from Trinidad and Tobago. As noted previously, she goes on to say, Lord Nichols's dictum related to cases falling within Section 109 subsection 1C and Section 109 subsection 1D of the Constitution, and not to appeals falling within Section 109(1)(a). Now, what she was saying there is the cases falling within the previous two sections, to which she's saying the need to demonstrate pass the test of disputable issue, related to appeals arising on a question of the interpretation of the Constitution and cases in relation to redress being sought for contravention of the protection of fundamental rights of freedom, but not to cases where it was a final decision or judgment in relation to civil appeals, respect of property and the right of a specified value. So that distinction was made, and she goes on to deal with the Court of Appeal's inherent jurisdiction to prevent abuse of process, and to also state, and I believe this would be the same principle in relation to Court of Appeals generally, that there was an inherent power to prevent abuse of process. And unless that power, and I quote, was taken away in a particular case, which would require the intervention of Parliament, or by a decision of the Privy Council in language which expressly or by necessary implication does so, the court retains that power. I don't see the latter happening at all. So what we can deduce, to take away from looking broadly at the treatment of the as of right appeals and the test of the disputable issue test, is that both the Caribbean Court of Justice and the Court of Appeal of the Bahamas in those decisions do not consider first that Alien Forte supports the proposition that in as of right appeals arising from a final judgment or decision given in a dispute respecting property or a right in a specified value or more, that the applicant must demonstrate a genuinely disputable question of law or fact. So that's a civil appeal. But however, they said that secondly, the Court of Appeal had the power and jurisdiction to strike out for abuse of process on hearing the applications in relation to issues involving the interpretation of the Constitution and issues involving fundamental rights. So you see, that takes us back to the four categories and how the Court of Appeal and Caribbean Court of Justice have dealt with this question of genuine disputable issue insofar as it's a test. I hope that I've given you a sort of bird's eye view in what is a very interesting and developing area and actually can go on. I haven't gone into some of the tests in relation to special leave where the Privy Council itself grants permission. And there'll be crossover where the appeal is brought in relation to permission for an appeal where the court below wrongly refused an as a right appeal, but of course there are civil and criminal appeals, and I haven't dealt with that. Anyway, that's my lot. Thank you very much.
Thank you very much, Desiree. I must confess, I hadn't realized quite how complicated it all is, actually. I mean, sitting in the Privy Council, I normally didn't get too involved with those sort of issues about how it had got there and whether it should have been stopped or what you talk about. I think the very interesting policing role of the Court of Appeal. So I think that is an important area, and thank you very much for helping us on that. I don't know whether Richard or Rowan want to comment at all on that point on Desiree. We can come back to it later at the end. Right. Well, I think now it's been offered to me a chance just to say some thoughts about practice and procedure and how things should be done. I must say, it has been very interesting, as I said, since I've left the Supreme Court, to be sort of looking at it a bit more from the point of view of the litigants and those advising them. And I must say, I've become aware of quite a number of sort of pitfalls, which I probably had been protected from as a justice. I have found enormously useful a book called Privy Council Practice by Lord Mance and Jacob Turner, who was his former judicial assistant. I remember that they were working on that when I was in the Supreme Court, and I thought it would be very interesting. But I must say, since looking at these issues, I find it. I do commend it to those who are worried about Privy Council practice. It does manage to draw together most of the important rules, and in a way which I find very helpful. I think I'm not going to try and get too deeply involved in issues. I think perhaps I just draw attention to two sort of areas. One is the question of preparation of documents for the Privy Council. Now, sitting in the Privy Council, one receives a great pile of documents, and one looks hopefully for something which shows you the way through. I had a particular dramatic introduction to this, because the first ever case I did in the Privy Council was an appeal from the Cook Islands. It was the first ever appeal there'd been from the Cook Islands, and it concerned issues of ancestral Maori title to land in the Cook Islands. Now, I wasn't a great expert on Maori title in the Cook Islands, and indeed none of us were. But I came back from a rather good lunch after I'd been sworn in and found this great pile of papers. And I searched for something which would provide me with a clue to what it was all about. And I'm afraid I didn't find it. And actually, in that case, we didn't really get to grips with the issues until the second day of the case, when we had a lawyer from the Cook Islands. We'd had main lawyers who had appeared were New Zealand leading counsel, who were excellent, but the person who really knew about it and addressed us on the second day was a solicitor from the Cook Islands who actually understood it all, and that was enormously helpful. Now, that's rather an extreme case, but I was interested to see, you start off with something called the record. Well, the record is normally produced by the local court and has it tends to have everything in it. But I see that in the guide that I've been reading, the Mance guide, it says this, 479, although the wording of Rule 20 might not make this clear, a distinction is recognised between the certified record, certified by the registrar overseas, and the reproduced record produced for the purpose of the proceedings. And it says, ideally, the proper office of the court should be assisted by the parties to limit the certified record to such documents as are necessary for the hearing of the appeal. Although in practice, the record certified is often a complete record of all the documents created by the proceedings. Then it goes on, for this reason, as soon as the certified record becomes available, the parties should collaborate to reproduce a more limited and appropriately ordered and paginated record containing the documents actually needed for the purpose of the appeal. This reproduced record should correspond with the e-bundle prepared for the same purpose. Now, I don't know how often that's achieved in practice, and I suspect it's not as easy as it sounds there. But the number of times I found myself faced with an enormous record of, 4 or 5 volume, lever arch volumes of documents, searching for the key documents, which are usually the judgments of the courts below, and 1 or 2 of the other documents. So I think it is worth trying to see how one can provide the court with a record which is really helpful. The next thing they go on to is the statement of facts and issues. And it says the JPC expects parties and the lawyers to cooperate sensibly in the production of an agreed statement of facts and issues, and does not welcome a statement containing passages identified by either party as not agreed, still less a statement with alternative versions of particular paragraphs or separate statements of facts and issues from each party. Now, the number of times I've been faced with the sort of documents which have alternative statements of facts for statements the parties couldn't agree, it really should be possible to do. And what one's talking about here is just the basic uncontroversial facts, a chronology, the main things that happened in the description of the property and so on. And it is extraordinarily helpful if that can be done and done by agreement between the parties, because otherwise one starts off completely on the wrong foot. One aspect of that, which I think is, again, people forget about, is the need for plans. Now, if you're dealing with a case about property, it's almost critically important that you have a legible plan, usually with colours. Now, there may be problems about reproducing that in the documents, but if so, we'll make sure that the board has a separate copy of the relevant plan so it can actually see immediately what the case is about. Now, these are sort of probably very basic and obvious points, but it's extraordinary how often one faces great difficulty in trying to get to the bottom of what it's all about and to find the critical documents. And then, even more important, the case, the statement of case. And here again is quite helpful. The guide says the case is a statement of a party's argument in the appeal. The JCPC does not prescribe any maximum length, but quotes favours brevity, and a case should be a concise summary of the submissions to be developed, close quotes. Now, I was very pleased to see that, because it's amazing how often people seem to think that because they're coming to the Privy Council, they've got to be very long-winded. And of course, the reverse is the case. It should be possible to state, if you've got a good case, it certainly should be possible to state it concisely. A long case is often an indication that the parties haven't worked out what their case is or are not sufficiently confident of it. And so when I've been looking at sort of cases for the purpose of advising people, the main contribution I make is cut it down by a half. And but particularly make it quite clear at the outset, at the beginning of the case, why the case, what is the point of law, why it's important, what are its implications, because those are the things that as a member of the Privy Council one's looking for. One wants to be interested, one wants to understand immediately why this is important and what is significant about it. One doesn't want to have to dig around in pages and pages of references, quotations from cases and so on. You're going to assume that the Privy Councillors know most of the basic cases, so you don't need to have great citations. What one needs to be focused on the real points. So that's a fairly obvious point, but probably worth mentioning. Now, the other aspect is how you present the case to the Privy Council, either in an actual hearing or, has been tending to happen recently, a virtual hearing. I think it is terribly important to understand that the members of the Privy Council, although they are very experienced, may not be familiar with the particular issues affecting the jurisdiction you're dealing with. I mean, the Cook Islands case was perhaps an extreme example, but in most cases, the one starts off from a jurisdiction and a system of law which will have some parallels with other systems one's familiar with, but will have its own distinctive features. And so I think it is very important for those presenting the case to make sure that the court has the information necessary to understand the particular features of the jurisdiction, the particular any other particular circumstances which are important to the background of the case. I think it's also important to be conscious of the extent to which a case affecting one particular jurisdiction has implications for other jurisdictions, particularly in the Caribbean, where you find a lot of common ground. But it's very useful to know whether a case is going to affect a number of other jurisdictions. And another thing which is terribly useful to know is whether a particular law one's dealing with, a particular statute, is derived from a statute of some other jurisdiction. I mean, often in company law, the statutes will ultimately be derived from the English company law. But sometimes one finds statutes derived from Canadian law or Australian law, whatever it may be. And so it's very useful to have that sort of background. And perhaps relevant to that is the representation. You know, by the time one gets to the Privy Council, one often has a high-grade silk appearing, or the equivalent from the jurisdiction, and one values enormously their help. But I often feel that probably sitting behind is a junior who actually has been doing the case throughout and may know a certain amount more about it than the leader does. Now, I don't want in any way to decry leaders such as Richard here, who's always on top of every aspect of the case. But I think, I mean, to mention, I mean, I remember one case from Mauritius. Now, Mauritius is a very interesting jurisdiction because it's sort of French and English, sort of marries the two systems. So one often finds issues which are quite tricky to get your head around. And there was one particular case where we were dealing with the planning law of Mauritius, which has some parallels with the English system, but not that close. And I remember I was sort of puzzling about it. I mean, I know quite a lot about English planning law, and about some of the Commonwealth systems, but it was the aspects of it I was puzzling about. And it wasn't until the junior for the respondents, for some reason, decided to follow the leader. And he is quite clear that the junior actually knew the planning statutes backwards. And at that point, one began to, I really think I got on top of what it was all about. So, I mean, it's a slightly odd advice to be giving you, but I think it's very important to make sure that the court has helped as much as possible, because we are feeling our way and we need the help from counsel, senior and junior. I think the development of sort of online hearings has been quite difficult, I think. I mean, I think people have done very well to get around it. I don't think there's any particular tricks. I think on the whole, as long as the equipment works well, that's fine. I did find in one or two cases that the problem of plans, I come back to this, I mean, because I'm particularly interested in property and planning cases, that it's absolutely critical for the court to have the plans, and it's quite difficult sometimes to do that online. So somehow it's very important to try and make sure that where a plan is critical to it, the court actually has it physically available. So those are just some thoughts based on my experience. I think now we've got another sort of 5 or so minutes. I wonder are there any questions? There aren't any Q&A questions, I think. I don't know whether there's any questions in the chat. But Richard or Rowan, do you want to comment at all on what I was saying about sort of practice?
Well, I think that was really, really a good insight, actually. I think one of the things, because I was a judicial assistant in 2012, which I think is when you first joined.
Yes.
And I remember that just being astonished about how many cases the Privy Council and the Supreme Court were dealing with. And I think there's a tendency to think when one is appealing to the Supreme Court or the Privy Council, because you have lived and breathed the case, and because it's complicated and there's this history to it, that and because, as you rightly say, you know, this is the final Court of Appeal, this is the big deal, it has to be presented in this incredibly detailed and drawn out way, whereas of course actually the reality is the justices are just some very, very, very busy people. And actually it's the case, well, I won't name the particular justice who it was, but I remember we had a very, very complicated case on discrimination, and one side had filed submissions, I kid you not, 330 pages long. And this particular justice said, well, I dealt with that quite swiftly, I just read the other sides. And then I thought to myself, there's a lesson.
No, I mean, you're quite right that actually one is looking, when one gets this great pile of papers, one is looking for the thing that's going to be the most helpful at getting to the heart of the case. And so you want to make absolutely sure that it's your submissions that actually do that. Richard, do you want to add anything on? You need to demute.
The thought which I had was really about style. I think you will seldom go wrong in the Privy Council if you understate your case. Telling the Privy Council this is the most important case they'll ever heard is very irritating. Or even, this may seem a bit unfair, but there are rhetorical flourishes one sees in cases which one litigates in the Caribbean, which tend to fall on deaf ears in the Caribbean, in the Privy Council. So I think a careful and moderate approach to how you put it helps them. And also, there's a small point, but normally something's gone wrong, and one must well remember we're often dealing with English people. Beginning a case with an apology is always a very successful approach.
So, Desiree, do you want to add anything?
Well, I think to be fair, the problem about the incidents to which Lord Carnwath referred is really quite profound, and that's before you run into sort of the e-bundle and the record being differently paginated. So there's just so many difficult problems. There's always plenty to say sorry about at the beginning of the case.
Good. Well, thank you for that. Desiree, do you want to add anything on?
I just thought the point made about making use of the entire team was a very good one. You have the juniors behind who might know of a particular point, because what the Privy Council, what the judges really want is to know what the case is about and help them with difficult aspects. There certainly is a convention in England here where we are led. Silk will often give a junior an opportunity to deal with certain points, and it's really worth considering it if you from another jurisdiction and have a junior with you. So I think that point is a good one. Thank you.
Yes, thank you. We've got two questions have come up on Q&A. One is, to what extent does the Privy Council consider the local realities in considering cases that come before them for consideration? Well, I think the answer is we try, I can answer that really. We try to, as far as possible, to understand the local quotes realities, although it's not always easy to sort of get to the root of that. But I think it's very important for the parties and council to make sure we do. The other question from Audley Quello is actually a rather complicated question about Bermuda's statute governing appeals from the Court of Appeal. Oh, I see there are different statutes, and the question is which is actually active. I think probably, I don't know whether Richard or
Not off the top of my.
no, I think probably
Why?
I think that's going to be rather too complicated for us to try and sort out. But I'm sure
Well, I've copied and pasted it
yeah.
onto, so we'll have a think about that. And
Yes.
whoever it is, can I just ask before we finish there? We've got our email addresses here. Is it a good idea if I just put those onto the chat?
I think it is. Could you put, I put mine?
Yes. And that way, certainly Audrey, you could get in contact with us by email. And if anybody else wants to get in contact with us by email and ask us to assist with anything, then you've got our contact details.
Yeah. All right. That's very helpful. And I think at that point we've come up to 3 o'clock, and so it's probably the right time to draw this session to a close. It leaves me simply to thank our 3 excellent speakers for their contributions, which were very stimulating. And I've enjoyed these 3 sessions very much, and I'm grateful for Richard and Rowan for organising them, and for Desiree for joining us for this last one, and maybe we can repeat it in the future. So thank you very much from me, and I see Brian is back there and is applauding us. Well, that's very nice. Thank you, Brian. So on that note, we'll say goodbye. Thank you all very much.
Thank you very much.
Thank you. Thank you.